All rise.
The Honorable Justices of the Supreme Court. This court, from recess, now sitting.
Thank you. Please be seated. Now turn to the third case on this morning's docket. That is case number 103674, State of Kansas Appellee v. Ryan Cox, Appellant.
May it please the Court. Rebecca Kurz on behalf of Mr. Cox. May I reserve 3 minutes for rebuttal, Your Honor?
3 minutes is granted.
Thank you. I would like to focus my argument today on the third issue raised in my brief, which concerns whether my client's Sixth Amendment right to a public trial was violated when the court closed the courtroom during the testimony of the nurse who performed the sexual assault examinations on the 2 child victims in this case. The courtroom was closed only for that portion of her testimony in which she used photographs taken during the physical examination of the 2 girls' genitalia. I can't tell you how much time the courtroom was closed. I can tell you that this witness's testimony covered about 35 pages of the transcript, approximately 10 pages or 1/3 of that. The courtroom was closed during that period of time. I can also tell you that this was a critical portion of testimony in that, but for the physical findings in this case, it would have been a he said, she said sexual assault case. But the physical findings were highly consistent with penetration. The court has to find 4 things before a courtroom can be closed. The party who wants to close the courtroom has to advance an overriding interest, likely to be prejudiced if the courtroom is not closed. 2, the closure must be no broader than necessary to protect that interest. 3, the court must consider reasonable alternatives to closing the courtroom. And 4, the court must make findings adequate to support closure. We do not have any of those 4 elements in this case.
Did the defendant object to the district court's lack of findings, the failure to make findings, as you allege?
Defense counsel did not make a specific objection as to lack of findings. Defense counsel's objection was very simple. He didn't mention the Sixth Amendment. He simply said, I can't agree to the closing of a public trial. Now, I think that's adequate to preserve the issue for review, but I would point the court's attention. I believe it is Dixon and Ulate. I'm not sure how to pronounce that. Ulate. In both of those cases, the issue, including adequacy of findings, was reviewed by a Kansas court, even though no specific objection was made as to either Sixth Amendment or to factual findings. Now, putting up pictures, photographs of these young girls, they were 7 and 9 at the time of trial, of their genitalia, obviously that's embarrassing, and I can understand that. And I can imagine that nobody would want that. But all of the cases I've reviewed, the ones cited in my brief, and I believe the ones cited in the state's brief, all require a particularized showing, case-by-case analysis, not general assumptions as to who is embarrassed or who might suffer psychological trauma by having to testify or to have photographs such as these displayed. If the rule were to be different, if we could make general assumptions, this would be embarrassing for anybody. This would be traumatic for anyone, especially a child. Then the United States Supreme Court wouldn't have decided Globe newspaper versus Suffolk County, Superior Court of Norfolk County, I think. In that case, the court was examining a state statute, I think it was out of Massachusetts, which said that in child sexual assault cases, the courtroom will automatically be closed in any case in which a child testifies. The court said you can't have a generalized determination like that. It had to be particularized, case-by-case analysis. And they found that statute to be unconstitutional because it deprived not just the defendant of a public trial, but the right of the press to be in the courtroom as well. Another thing I would say about embarrassment, this again has to be an overriding interest, not just a substantial interest. And you have to consider, in this instance, the courtroom was closed. Jury, attorneys, parties, court personnel remain. All public spectators, including family members, are out. Still a lot of people that have to view these photographs. The embarrassment is still there, even if you close the courtroom. Also, most of the cases, I think I mentioned already, talk in terms of psychological trauma that can be an overriding interest, not merely embarrassment. In this case, the prosecutor made a second attempt to close the courtroom when the children were going to testify. The court asked her if she had any evidence, testimony, such as from a counselor who could say, would the kids be traumatized? She didn't have that. And then when the second request was made, the court denied it. So we know if he denies the second one, he's not finding an overriding interest. He's not finding that embarrassment is enough. He's not finding that generalized versus particularized findings are enough. The two rulings are inconsistent. He had the same information for both occasions. Now, you also have to consider other reasonable alternatives. This prosecutor wanted to put these photographs on some type of machine that would enlarge them and project them on a screen. Apparently the screen, and this isn't on the record, but I'm assuming that the screen is seen by everyone in the courtroom. It couldn't be manipulated in a way that only the jury would see it. That was not her only alternative. She could have simply asked the witness to come down off the stand, point to the photographs. If the photos are small and she needed to approach the jury, I imagine the judge would have let her do that. And the photographs could have been passed to the jury. But I also think it's important to note that this request was made in the middle of trial. This prosecutor had to know that she wanted to use these photographs. If they weren't large enough to be shown to a jury just by holding them up, she could have had them enlarged. They could have been put on an easel. The witness could have come down and pointed to whatever it was she needed to point to. I think that by making this, I think this problem is totally of the state's own doing by making this request mid-trial. This easily could have been anticipated. It could have been raised prior to trial. Evidence could have been put on as to the overriding interest that the state claimed it had. The judge would have been in a much better situation to make factual findings. I understand that in some cases things come up in the middle of trial and judges have to rule on it. This isn't one of them. This could easily have been taken care of at a time when all reasonable alternatives could have been examined, both parties could have discussed them, and specific factual findings made.
Is there a harmless error component, or is this structural error?
It is structural error, I think, under Arizona versus Fulminati, which specifically mentions that closure of public trial falls within the rubric of structural error. I think the Kansas case, which best illustrates that, is Dixon. In Dixon, the court closed the courtroom when the verdicts were returned. That was done because there was a second co-defendant to be tried immediately afterwards. They didn't want that jury to hear what the verdict was. Obviously, if you're closing the courtroom and the guilty verdicts are already in, that closure couldn't have had any conceivable effect on the verdict in that case, and yet reversal was required. No finding of harmless error. That analysis, I don't believe, was done in Dixon.
If the problem in this case is that the district court blew past the factual findings that it has to make in order to properly close, why isn't the remedy here just for us to remand this case back, let the trial court and the parties make their factual findings, and then come back up and kick the tires on whatever happens, rather than just reversing right now?
3 reasons, Your Honor. And what you're suggesting is what the court did in United States versus Galloway, which is a 10th Circuit case cited in the state's brief. It is distinguishable. First of all, Galloway is a partial closure case. This is not partial closure. All spectators were removed from the courtroom. I think that's at page 230 of volume 8 of the record here. Partial closure cases are decided under a different standard. There is only the party wishing closure only has to put forth a substantial interest, not an interest that overrides the defendant's Sixth Amendment rights. Total closure, you must have the compelling and overriding interest. 2, and most importantly, I think in Galloway, the opinion says the district court, quote, undoubtedly considered the factors of the victim's age, nature of the offense, and potential for harm to the victim. We don't have anything to suggest that the court considered those 3 factors in this case, and I'm not saying that those are the 3 that you have to consider. Those are the ones named in that opinion. There could be more. Age would be apparent. Nature of the offense would be apparent to the judge without an additional record being made, but potential harm to the testifying witness is not apparent. That has to be established by evidence of an overriding interest. Also in this case, as opposed to Galloway, where they say the court undoubtedly considered it, the request was made and the ruling came right on top of it. It's very quick. I think it's apparent from the transcript that really wasn't any time for anything to have been considered. Third, the remand in the Galloway case was not so that the trial court could make findings of fact. It was so that the trial court could supplement the record with findings already made. I think that's a crucial distinction. If you say we're going to remand for the trial court to make findings, you're giving the other side a second bite at the apple to make its compelling overriding interest.
Well, but here's where I'm coming from. Defendant didn't object to the district court's insufficient findings, so you bear a little bit of responsibility there. I don't think we get to blow past that. You're supposed to help the trial court and correct its mistakes at a time when they're correctable. So you get a little bit of a problem. And there is case law that says that you can remand these things to now look more closely at the decision that was made instead of just reversing the conviction and going back and doing it over again.
I don't recall seeing case law in full closure of the courtroom cases allowing remand. I'm sorry, I just don't recall one. I do recall seeing cases, at least cited within the cases that I cited, listing partial closure cases. And I apologize. I think that this is in Waller. I know I read this. The court has a duty to make findings regardless of whether the parties request them. I believe that is in Waller, and I think that would address your question.
Counsel,
Well,
I see you're
I see I'm out of time,
Do we
yes.
have any more questions? Thank you, counsel.
Okay, please the court, Chris Elsleger, up here on behalf of the state. And obviously I'm going to dispute my opposing counsel's assertion that none of the 4 factors in Waller were present here, I submit that all four factors are present in the record.
But do you agree that the judge did not articulate any findings with respect to the factors?
I would submit that the record is very sparse, but he did make findings. There are findings there. He explained his reasoning when he announced the closure. He noted the personal nature of the photographs, the graphic nature of the photographs, and we can't lose sight. I mean, we're talking about photos of the genitalia of small children. Clearly a sensitive subject. In most cases, it is unlawful for anyone in the public to even see this type of material. It would be considered child pornography. I'm not suggesting that this was child pornography, but it's in the same ballpark. It's a very sensitive subject. It's pretty obvious to everyone.
But before you get on further down that road, do you dispute counsel's statement that the trial judge was under an independent duty without being requested to make findings with regard to the factors and the reasons for closing?
Well, again, I think the judge did make the findings, but I do think also it's incumbent upon the defense counsel, if they don't think the findings are sufficient to warrant the closing, that they need to raise an objection to that.
To the adequacy of the findings?
Yes.
Okay.
And I'm going to go back to the beginning. I think that the overriding interest, I think, is, as I mentioned, is rather obvious. It's one that's been recognized by the courts, by the 10th Circuit, by the U.S. Supreme Court and Globe newspapers, that safeguarding the physical and psychological well-being of a minor is a compelling interest. And I cited other cases, I think, in the brief where courts have said safeguarding child sex abuse victims, their psychological, emotional state is a compelling overriding state interest. So again, I don't think that there was a lot of need for argument on that. It's already been recognized by the court, and I would submit again that defense counsel didn't really put up a fight on that. He said, "Yeah, I understand. I see where they're coming from."
What about reasonable alternatives?
There were reasonable alternatives, and again, there is precious little in the record. But the judge did sit back and kind of thinking out loud. He said something along the lines, "Well, if there was any other way, if you had a video, but then the witness would still have to point at it." And then the defense counsel suggested, "Well, how about we just pass the pictures, the photos along to the jury?" And the prosecutor pointed out, "Yeah, but I still need the witness to point to explain the injuries and so on and so forth." And so there was consideration of the other alternatives. So what I'm submitting to you is all four factors are there. The real question is are they sufficient? Are those there's no, in the case law, there's no quantum, or there's no rule about the quantity of alternatives that must be considered. It just says the court has to consider them. There's no defined quantity of findings. It just says findings that are sufficient for appellate review. And I submit that while the record is very sparse, the findings are there, the alternatives are there. The court can review them and determine whether or not it was a proper closure. And I would submit to you that certainly it was. I mean, the sensitive nature of the photos is obvious. We're talking about little girls, victims of sex abuse. I don't think you need a lot of expert testimony to come in and provide evidence about the emotional trauma they might suffer. The closure.
I'm just going to ask, what if we disagree with you and find that it was error? What do we do in your view?
Well, again, as I set forth in the brief, I think there is the option of remanding for the district court to explain its findings and its reasoning and then bring it back up to review. Because I think the problem here isn't that the four factors weren't, the court didn't go through the process. It's just a very sparse record. But I think that the alternatives are there, the findings are there. It's just a very sparse record. So if you're not satisfied with the record, I think the court can remand it, as the 10th Circuit did in the case cited, for supplementing that record to explain.
And as I understand from your statement, this would, since there are what you could consider to be sparse yet sufficient findings in the record, a remand would be simply asking the judge to further explain what the judge meant. It would not be taking on any other evidence. It would just be recalling what had happened months ago.
Yes, I think that's fair. Because I think I was, like as I said, I think the court did what it needed to do. It considered the alternatives. It made the findings. It just didn't make an exhaustive record of it. But I think the record is sufficient to affirm clearly. But if you disagree, then a remand for that purpose, I think, would be appropriate.
Well, first, a follow-up to that line of questions. Do you have any authority in a full closure for remand? And do you agree that there's a distinction?
Not off the top of my head. The case, I did cite the 10th Circuit case in the brief, and I'm not recalling if that was a partial or total closure. But I don't, off the top of my head, no, I don't. I can't give you a case site. But I think the rationale still is the same. I think the same, the same justification applies as in that case.
The question I was going to ask earlier relates to, do we take into account the fact that I at least see some validity to defense's argument that the state kind of created this. The state before trial would have planned a different method of presentation, then the photos could have probably been displayed on an easel that was turned away from the public view, or something similar. And so really it's the fact that they chose to display it on a large screen that was that creates this issue. Do we take that into account in the analysis?
Well, I certainly you can, but I also want to point out that something else to take into account is that the Attorney General's office prosecutes cases all around the state, and every courtroom is a little bit different. Some courtrooms, you go to Lyon County, boy, they're high speed. They've got all the technology and everything. You go to other courts, they're very austere, and we don't know. We're not always in the same courtroom, and the prosecutor doesn't always, I think, have doesn't always know exactly what they're going to get when they get to the courtroom. It doesn't know how it's all going to pan out. I don't recall which county this.
Labette.
I mean, that's far far south. So the prosecutor obviously headed down there. I don't know, probably a day or two before trial, and I just think you have to take into account the fact that this is not the same. Prosecutor's not operating the same courtroom every day. This isn't a courtroom she's familiar with, and yeah, you can always go back in hindsight and second guess, say, well, they could have done this or that or whatever, but that kind of assumes a lot. That assumes
that loses a little steam when you consider that it is an unusual circumstance that you would have these photos and that you would have this circumstance. I mean, we have a whole bunch of sex abuse crimes that come before us, and this is the first time I can recall having that issue. And so when you have a unique issue, I would think that the prosecutor would have some prophylactic responsibility up front in that regard.
Well, certainly, but I would submit too, though, that again, knowing from this came out of my office, I know we have a certain set of technological things that we use, the screen and the projector and so on. That's kind of standard material that the prosecutors take around the state when they present these cases. And again, each courtroom is different. I don't think you can necessarily say the prosecutor had this prescient knowledge about what she was going to have and so on. Certainly, I mean, in hindsight, yeah, things could have been done differently, but I don't think that's necessarily the standard that we look at.
Doesn't that cut against your argument? If this was the standard operating procedure, she knew she would be using a video. She knew she would be putting it on a big screen. Wouldn't she, or have had the ability to have thought about an alternative method of presentation of something that was sensitive versus knowing that she was going to make a request to close a courtroom?
Yeah, I'm not sure that I'm saying that she didn't consider alternatives. I mean, she knew that she had to have this. She wanted to present the photos in a way that the jury could see, and at the same time that the expert could point to different injuries on the photos. And I don't know what her thought process was. I don't know the layout of the courtroom. I actually don't know the actual technology that she had. Some of this is me surmising and speculating. But at the same time, that's what opposing counsel is doing too, is surmising and speculating. So I'm just speculating in the other direction. But I think ultimately, though, the court was presented with here's what I've got. There's an overriding interest in protecting these girls from trauma, embarrassment, whatever. It's a very sensitive subject. I'm just asking to close the courtroom for a few minutes while we go over these photos. And again, defense counsel really didn't put up a fight on this. He just kind of said, yeah, I understand. I don't think the spectators want to watch this either. And he kind of half-heartedly said, yeah, but I'm still going to object. But he didn't really put up a fight on that, and he didn't demand any kind of findings on alternatives or the factual findings supporting the closure. He said over and over again, I understand. So when all the parties are kind of in agreement like that, saying, I understand, it kind of leads the court to a point where he doesn't feel like he probably needs to make a whole lot of findings on the record because nobody's putting up a fight. And that's why we have the sparse record here. The defense counsel really didn't put up a real fight on this. So to some extent, there's a little bit of waiver involved here. Certainly, he didn't challenge the overriding interest. So I'd submit essentially he kind of waived it. He said, I understand. He didn't really argue about whether the closure was any more narrow or broad than it needed to be. Really, he just made a general objection. I kind of object to the closure of the courtroom.
So when you approach the court and ask for closure of the court, it's not the burden on the state or the duty of the state to say, here's what we have to show. I have to show this, this, and this, and I'm going to do it right now, Your Honor? That
yes,
happen.
But then when the defense counsel says, I understand, I know where they're going, I'm not going to put up a fight, that leads everyone down a trail of, well, okay, we don't really need to argue about this because we all kind of agree. And I think that's what happened here. And if there are no further questions, then I would submit the other issues on the brief, and I would ask the court to...
On the third-party evidence, did I understand that the girls did testify that no one else touched them, including the Shirley's father? That was... My
understanding, if I recall correctly, is that they only fingered the defendant. They never suggested that anyone else.
But was there there's a difference between saying no one else did and having the specific testimony. Did this person ever touch?
Oh, right. Were they ever asked if the grandfather? I don't think that question was ever asked. But they clearly only identified the defendant as the abuser.
And the problem I have with that rule in these cases is that children of this age are often in a situation where jurors will think, how did they know to have the sexual knowledge to make these allegations if it didn't really happen? And when you allege that someone else did, then there's some relevance besides simply who done it in this case. You follow what I'm saying?
Right. Yeah. Although the same token, it doesn't connect or it doesn't exonerate the defendant, even if, and I'm not going to concede that there was any real evidence that the grandfather committed any abuse of these girls, but even if he did at some point in time, that still doesn't in any way change the fact these girls said at this specific time, this defendant did it.
It makes it more likely that they would have the knowledge to be able to make a false accusation, because that's often the implication. Well, how did they know enough to accuse this person if it didn't happen?
Okay, but still, I think in this case, it was the evidence, the third-party evidence, was just so attenuated and speculative that it just really wasn't relevant. It really could not connect the grandfather to the crime.
Do we have any more questions? Thank you, counsel.
Okay, Your Honor.
Reserve 3 minutes for rebuttal.
Thank you. As far as not knowing the setup of the courtroom, I remember at least one pretrial conference held in the county where the trial was. I recall that there was argument on the state's motion in limine regarding the third-party evidence, and I believe it was the same prosecutor there at those pretrial hearings as who tried the case. It's not a question of not knowing the courtroom. She knew. It could have been taken care of in advance, and she didn't do it. I disagree with the record. This is at pages 218 and 219 as far as the meaning of defense counsel saying, I understand. He's saying he understands that she wants to use these pictures. He's saying he understands that she's saying she needs to be able to point to them or have her witness point to them. But he says, I cannot agree to the cutting off of a public trial. Second objection, when they try to close it when the girls testify, is much stronger, I agree. It is, I forget who had this question, but it is the proponent's burden to come forward with the evidence and establish the overriding interest. It's not our duty. I believe it's Judge Johnson had the question on the third-party evidence. This would be exhibits 2 and 3, which I think are the DVDs of the girls' statements. I believe the younger of the two children specifically said, my grandfather did not touch me. The older child was asked if anyone else had touched her, and she said no. Grandfather didn't come up in that particular discussion. One thing that the state mentioned in discussing that third-party issue, I believe he said it doesn't exonerate Mr. Cox. I don't think that's the standard. I don't think we're required to prove beyond a reasonable doubt that grandfather abused these children, not Mr. Cox. It's a lower threshold than that to get third-party evidence on.
But haven't we, in the cases where we've said it should have been allowed in, there was something there, some evidence to support that it might have happened rather than just simply allowing that as a hunch, grandfather might have done that, that there had to be some kind of evidence to support the theory that some other person did it.
What we have here, they basically wanted 3 things in. They wanted the mother's statement when she talks, when this is first disclosed, she's talking to the police. Mr. Cox didn't abuse these children. If they were abused, my father did it. That apparently, and I'm going to refer you to Volume 1 of the Record on Appeal. I believe it's page 77. That's the defense's response to the state's motion in limine to prohibit this evidence. I think paragraphs 5 and 7 are going to be most pertinent to you as to what it was the defense was trying to show. It's the comment by mom, and it's also then the fact that apparently further investigation was done by law enforcement in this case, and they actually found the young woman who claimed that the grandfather had sexually abused her when she was a child. It says that she had reported it to her pastor, who in turn told the girl's parents. However, the family made a decision not to press charges against the grandfather. So it's not like the cases where third-party evidence is denied as being too speculative, where it's some kind of rumor in the neighborhood. Hey, this guy's a child abuser. He was around that day. Maybe he did it. This is an actual accusation had been made, but we don't have a criminal conviction. But I don't think our burden is that high. The thing about the mother's statement that I would like to point out too is when she makes this statement, well, if anybody did it, my father did it. There's language in the Marsh opinion that says that the door can be opened to third-party evidence. It also says, I think, that you can sometimes cross-examine on that type of evidence if that third party is going to be testifying at trial. Now, that didn't happen. The grandfather didn't testify. But at trial, on direct exam, questions to mother, it's kind of portrayed that mom is on board, mom is very cooperative in this investigation. Comes out on cross, she's talking about, I had to spend so much time trying to get a protection from abuse order. I confronted Ryan, how dare you, or how could you do this, something like that. Comes out a little bit on cross that she really wasn't all that cooperative. She did say the girls were lying, but they wouldn't let her go so far as to say, well, I think the girls are lying because if anybody did it, my father did it. I think that's critical impeachment. I think they may have opened the door to that by choosing to portray her as somewhat cooperative. Well, I think that was my main point that I wanted to make on that evidence, and I've gone way over my time.
I just have, do you think that at the port, going back to the first issue that you initially argued, that we're talking about a couple of sentences in the transcript. Do you think that anyone who was discussing this understood the gravity of what was occurring here, that it was structural error? I
don't think so. I don't think so at all. And I think that's another problem with raising this mid-trial. The prosecutor did not do the judge any favors in this case. And I don't come to oral arguments and make excuses for judges. I'm trying to get my client a new trial. But she didn't do her homework. She didn't say, Judge, there's a test here. Here's what I'm asking for. Here's my burden. Here's my evidence. She hung them out to dry.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this case under advisement.